When an accused is residing in a state different from the state where FIR is lodged, the accused can seek a transit anticipatory bail in the state they are residing in. Transit anticipatory bail is a limited time bail. For instance, an FIR is registered against A in Delhi, but A resides in Mumbai. A will have to apply for bail in competent jurisdiction, that is Delhi. However, chances of arrest during this time period are there and travel may also occur. Hence, A can apply for transit anticipatory bail before bail is sought in the court of competent jurisdiction. It is a temporary measure to safeguard individuals' liberty and rights. Most arrests will happen where the accused is residing. Hence, the Supreme Court came with the concept of transit anticipatory bail, which is a protection for the accused against arrest that can occur before he reaches a court of the territorial jurisdiction where the FIR is registered. So the Supreme Court justified this provision by asserting that denying access to transit anticipatory bail based solely on territorial jurisdiction would restrict the powers under Section 438 of CrPC, potentially leading to a miscarriage of justice and contradicting the principles of access to justice. The Court of Session or a High Court can entertain a plea for a limited anticipatory bail, even if the FIR is outside its territorial jurisdiction, and they may consider transit anticipatory bail based on the circumstances until the accused can approach the competent court for full-fledged anticipatory bail. So the latest judgment that came was in the case of Priya Indoria versus State of Karnataka, where the accused husband and his family were granted extraterritorial anticipatory bail without issuing notice to the investigating officer and public prosecutor. It was in the police station of Chirawa, Rajasthan, because the estranged wife had lodged the FIR there. The bench continued the protection from arrest for 4 weeks to enable the accused person to approach the jurisdictional court in Rajasthan for anticipatory bail. So the infamous toolkit case where there were 2 transit anticipatory bails issued. So in this case, there was Bombay High Court had granted a 3-week transit anticipatory bail as non-bailable warrant was issued by 30 Hazari courts in Delhi. In this case, there was another accused who was granted a transit pre-arrest bail. This is a protection under the ambit of Section 438 of CrPC. The Bombay High Court in its order had mentioned that this was a temporary relief to protect the liberty and to avoid immediate arrest, so that the bail can be granted by the court of competent jurisdiction, and during the transit period or commute, the arrest does not happen. The Bombay High Court in its order mentioned that this was a temporary relief to protect the liberty and to avoid immediate arrest. And this can be granted by the court. Generally, the power of High Court in anticipatory applications are limited to its territorial jurisdiction. However, it was also observed that an application under 438 is made because there is a fear and apprehension of a proposed arrest of a person. So in the present case of toolkit, there was a strong apprehension of arrest. Also, the Supreme Court has held in its recent judgment that high courts and sessions courts have power to grant interim or transit anticipatory bail even when the FIR has been registered in another state. Conditions for extraterritorial transit bails have been set out in the latest judgment, which are detailed pointers that include that the IO has to be informed, the public prosecutor has to be informed. Also says that the order of grant of a limited anticipatory bail must record reasons as to why the applicant or the accused apprehends an interstate arrest, and the impact of such grant of a limited anticipatory bail or interim protection, as the case may be, on the status of the investigation. That is very important. So the jurisdiction in which the cognizance of the offence have been taken does not exclude the said offence from the scope of anticipatory bail by way of a state amendment to Section 438 of CrPC. So we have to consider that in mind. So there are a few more clauses that have been put by the Supreme Court that have to consider or that have to be kept in mind before the transit anticipatory bail is given. The one important point that the Supreme Court has put forth is to avoid forum shopping in such cases that happens. The Supreme Court has further laid down that it is necessary for the court before which the plea for anticipatory bail is made to ascertain the territorial connection or proximity between the accused and the territorial jurisdiction of the court, which is approached for seeking such a relief. Such a link with the territorial jurisdiction of the court could be by way of place of residence or occupation, work, profession. By this, it implies that the accused cannot travel to another state only for the purpose of seeking anticipatory bail. That is extremely important, that a travel should not happen to a different state. That will become forum shopping. That's why such strict points have been given, and it has been made clear explicitly to the court that these are the pointers that have to be considered. The Supreme Court had also said that the reason as to why the accused is seeking such a bail from a court within whose territorial jurisdiction the FIR has not been filed must be made clear and explicit to such a court, which is where the transit anticipatory bail is sought. Also, there must be a reason to believe that an imminent apprehension of arrest for non-bailable offence made out by the accused for approaching the court within whose territorial jurisdiction the FIR is not lodged, or the inability to approach the court where FIR is lodged immediately. The Supreme Court has reiterated that the power to grant extraterritorial anticipatory bail should be exercised in exceptional and compelling circumstances only, which means where denying transit anticipatory bail or interim protection to enable the applicant to make an application under Section 438 of CrPC before a court of competent jurisdiction would cause irremediable and irreversible prejudice to the applicant. I hope it throws a little light on the concept of transit anticipatory bail, which is often considered a judicial innovation. And if there are any questions to ask, it will make me think also, and I would try to do this in Hindi also. Not a promise, but we'll definitely try. Thank you for watching.